Good morning, ladies and gentlemen.
Good morning, Judge.
Good morning, Your Honor.
Okay. Mr. Irvin Keller.
Yes, Your Honor.
Good morning, sir. What can I do for you today?
Your Honor, I am here on the matter of People v. Owens, and we would like to put on the record that we will be waiving the the preliminary exam, having spoken with my client and the prosecution in this case.
Where is Mr. Owens?
Mr. Owens is incarcerated, Judge.
All right, Wayne County Jail. Good morning.
Yes.
Good morning, Your Honor.
Do you have a Denard Owens for me?
Denard Owens, I don't have him on the list. Let me look at the computer, see if he's in our custody.
Okay.
But is it Denard or Bernard?
Denard with the D, as in dog.
Yes, sir. Because I got Mr. Richard Hughes for you this morning, but he's talking with on another computer with another matter right now. But let me look on our computer for Owens.
Okay, thank you.
Yes, sir.
Mr. Macon, good morning. Mr. Macon, are you there?
So we do have, he should be zooming in from the 4th floor.
Okay, thank you.
6th floor.
Okay, appreciate it. Thank you.
No problem. Okay, I'll go my mark and bring it on.
Mr. Minkin, are you there?
Can you see me?
Yes, sir. I see you now. Good morning.
Good morning. I couldn't get any of my things to work. I finally got it to work off my phone. So,
Okay, great. You're here on Williams, correct?
correct.
Okay, we are ready on Emmanuel Williams.
Calling case number 240-561-99, the people of the state of Michigan versus Amanda Williams. Defendant is being charged with count 1, assault with a dangerous weapon, felonious assault. Count 2, assault with a dangerous weapon, felonious assault. Count 3, domestic violence. Habitual offender, second offense notice. Today is the date and time for probable cause. Please.
Good morning, Your Honor. Shelley Train for the People, P number 60249.
And good morning, Your Honor. Steve Mencken, P 31562, appearing on behalf of Samandra Williams.
And what's your pleasure, counsel?
Your Honor, we're going to set this for an exam. My client indicates that he has I think he has a tether, and he needs to be able to at least have it less restrictive. He needs to be able to get to his vehicle. He has all his possessions in there, including a phone and a wallet. He has like a temporary phone. That's why he's having trouble with his phone. And he needs to get that. He says he intends to, he has an attorney that he's going to retain, but I don't know if he has money that's locked in the car or whatever. And we just want to, I just set it for exam. And then if he retains somebody, that attorney will have to either be there or get it adjourned. He says he doesn't want to waive anything.
All right, the court will continue the plea of not guilty and set this matter for preliminary examination on March 27th at 9:30. Is that a good date and time?
Let me make sure that I'm available. You said what date?
March 27th at 9:30.
Let me take a look. Well, I'll just I'll set it. If I have a problem, I'll switch it. If he retains somebody, then I don't have to worry. So you said March 27th at 10:30?
9:30.
9:30. Okay.
All right,
And then is there a possibility he can modify his tether?
he wants his tether modified because of what again?
Well, he needs to be able to go to his vehicle and get property. They're holding his vehicle, and he has everything in there.
House arrest?
I think he's on house arrest. And he said he also has a job that he's got a number of things that he's have a company that he works for called Movers Helpers. And he says that he's got work, and he does glass moving storage, also his own business, and he works from like 6 a.m. to 8. And so he's now tethered to his home and can't get out to do anything.
Okay, Ms. Drain?
First, I would like to inquire as to where his vehicle is, because if it's located at the complainant's house, I think that's problematic.
You know, I'm not sure. I don't think so. I don't think he has to go anywhere near these individuals.
Okay, I don't have a problem with him going to his vehicle to get anything he needs, as long as he is nowhere around the complainant.
Okay. I don't think that's.
Let's first figure that out, where the vehicle is. In the meantime, you can send me a proposed order to amend the tethering hours so that he can go to work that is verified.
Okay. I'm not sure which form. Do I make up my own form, or is there a specific form?
You make up your own.
Okay.
So upon verification of employment.
Okay, he can verify one of them. The other one is his own company.
Well, I don't think he's going to fire himself.
No. So, do you want you need something in the order that indicates his work hours?
He has to verify his work hours. I don't buy the whole company stuff. Everybody's in their own business now when they get locked up.
Well, I'll see if he can get the glass moving storage. So, if I can get that, is the tether hours removed, or he just gets certain hours?
Certain hours.
Okay. All right. I'll see what I can do.
All right. Thank you.
Thank you. Have a good day.
Thank you.
Mr. Magidson. Mr. Magidson. Yes, sir. How can I help you? Mr. Magidson?
Oh, good morning, Judge. This is Mark Magidson. I'm here on Mr. Dushan Ambrose. And he is requesting an exam. He's also detained, but I did talk to him last night, so I would waive his appearance for this proceeding.
Let me call the case.
Calling case number 240-56189, people of the state of Michigan versus Dushan Ambrose. Defendant is being charged with count 1, stalking, aggravated, habitual offender for the case notice. Today is the date and time for probable cause. Appearances, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And good morning, Your Honor. Mark Magidson on behalf of Mr. Ambrose, P number 25581. As I did talk to him yesterday evening, he is detained, but I do waive his presence for these purposes.
The court will waive the defendant's presence. What's your pleasure?
Your Honor, at this point, I would request a preliminary examination date.
Okay, how's March 27th at 9:30?
Judge, I have a preliminary exam in Pontiac at 10 o'clock. So that's I'm kind of that day or that morning is concluded for me. You can do the 28th. The exam, excuse me, the exam is at 10, but I have another evidentiary hearing in Southgate at 1:30. '28th is good.
No, it's not. It's my homicide day. Is your client in custody?
My client is in custody. Unless the court wants to release him.
No, I don't.
Okay.
That's problematic because the court is closed Friday for Good Friday.
Yeah.
So what do you propose, counsel?
So you said the 28th is your homicide day?
Yes, sir.
And the 29th you said is Good Friday.
Yes, sir.
Okay, well, there's always April Fool's Day. I can do that day.
All right, the court will continue to plead not guilty and set this matter for preliminary examination on April 1st at 10 o'clock.
10 o'clock, Judge?
Yes, sir.
Okay, Judge, could I request a DSU report, a bond investigation? He is detained, and I think there's merits to having his bond lowered.
I'll review or refer the matter to pretrial services for final recommendation.
Thank you, Judge.
Thank you.
Thank you, Judge.
We'll see you early next week.
Mr. Raj. Are you driving, Mr. Raj? It looks like you're driving.
I just pulled over to the side of the road, Your Honor.
Okay, what can I do for you?
I am on a case for Richard Hughes, Your Honor.
Richard Hughes, okay.
Calling case number 240-56188, the people of the state of Michigan versus Richard Hughes. The defendant is being charged with count 1, domestic violence, third offense notice. Count 2, weapons, firearms, possession by a prohibited person. Count 3, assault with a dangerous weapon, felonious assault. Count 4, controlled substances, possession, cocaine, around or another narcotic.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
Count 5, weapons, felony, firearms. Count 6, weapons, felony, firearms. Count 7, weapons, felony, firearms. Habitual offender, fourth offense notice. Today is the date and time for probable cause. Appearance, please.
Sorry about that. Good morning, Shelley Drain for the people, P number 60249.
Good morning, Your Honor. Attorney Sahar Faraj appearing on behalf of Mr. Hughes. Your Honor, is that him in the Wayne County Jail?
Yes.
Yeah, look, he's waving, he's nodding his head, Your Honor. Mr. Hughes appears via Zoom at the Wayne County Jail.
Tell us your names for the record, sir.
Richard Lee Hughes.
What's your pleasure, counsel?
Your Honor, we ask that digital discovery be sent over and that we set this for examination.
And how's March 27th at 10:15?
One moment, Your Honor. Your Honor, I'm going to be out of town on the 27th. Do you have any availability on the 26th?
26 is my homicide day.
How about on the
Sure. I'm sorry?
The 25th, Your Honor?
25th is too soon.
And April 1st is too late, correct? Yes, Your Honor, is April 1st too late? of a date?
It sort of is. I'm sure that Mr. Hughes would like to get court a little sooner.
Of course.
If I have to, I'll do April 1st.
I'm sorry, Your Honor.
I said, if I have to, I'll do April 1st, but it just seems kind of bad that we're taking vacations while the defendant sits in jail.
Well, Your Honor, my intention was never to take a vacation while my client sits in jail. It was just a scheduling issue. That only works out this way if you don't have any availability on the 26th.
No, as you're aware, my homicide days are Tuesdays and Thursdays.
Oh, I was not aware of that, Your Honor, so. Okay, if the Monday is too soon, Your Honor, I would be available on the Monday, even if it is too soon, if the court has availability.
I don't know if that gives the people enough time to get their witnesses.
Ms. Drain, could that be possible, or if we don't want to make Mr. Hughes wait until the 1st?
You're on mute, Ms. Drain.
Sorry about that. Okay, give me just a moment to look into this a little bit more. I'll try to make that work if I can.
I have to give you at least 5 days.
Thank you, Your Honor. I was able to contact the complainant and she is available to come to court on Monday.
All right, March 18th at 11:45.
March 18th, Your Honor.
I'm sorry, not the 18th. March 25th at We can do 10:15.
That works with defense, Your Honor. Thank you for being accommodating, Ms. Drain.
Yeah, thank you.
We continue. Thank you.
Thank you.
Thank you.
Okay, Mr. Kenneth.
Good morning, Your Honor.
So you're here on that case where we've been trying to locate the defendant, is that right?
I'm on that one, and then Jeremiah Runnings is a matter that was set over from Judge Sabri yesterday because it's a domestic violence case for PCC today. I'm on those two.
Okay, what's the other defendant's name?
Jeremiah Runnings and Raymond Craig.
Craig, okay.
And Mr. Runnings is on the Zoom. Mr. Craig is the one who I believe is in the Department of Corrections.
You have the Craig on this. Do I have the APA here on Craig?
Yes, that's me, Judge.
Okay.
Case number 240-55298, people of the state of Michigan versus Raymond Craig. Defendant is being charged with count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, assault aggravated, habitual offender, or defense notice. Today is the date and time for a hearing. Appearances, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
May it please the court, Neighborhood Defender Service of Detroit by Jeffrey Konecki, P64800 on behalf of Mr. Craig. Your Honor, it has to waive Mr. Craig's presence. He is in custody somewhere. We're just trying to figure out where so we can get him before the court.
The court will waive the defendant's presence. I thought we found him in Jackson State Prison.
Okay.
He was in an England reception center. So this matter was scheduled for preliminary examination, but because we were unable to locate Mr. Craig at the time, we thought he was in the Macomb County Jail. And he is not. He's with the Michigan Department of Corrections. We could not go forward with preliminary examination, so we need to reschedule that and give us 2 weeks to do so because it takes that long to do the writ. So April 3rd at 10 o'clock.
Judge, would you have anything either a little bit earlier or a little bit later? I have a sentencing scheduled at that exact time, 10 a.m.
I can't do earlier because we don't get the prisoners before 10 o'clock. Is 11 o'clock too early?
No, that should be good. The sentencing is in 36 before Judge Robbins, so in theory, it shouldn't take too long.
All right, let's say April 3rd at 11 o'clock.
Sounds good. Thank you, Judge.
Thank you. Madam Clerk, we need to writ the defendant from the Michigan Department of Corrections. All right, we're ready on running.
Yes, ready and running, Your Honor.
Calling case number 240-56103, the people of the state of Michigan versus Jeremiah Running. Defendant is being charged with count 1, assault with intent to do great bodily harm, less than murder or by strangulation. Count 2, assault with intent to do great bodily harm, less than murder or by strangulation. Count 3, domestic violence.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, P number 60249.
And may it please the court, Neighborhood Defender Service of Detroit by Jeffrey Konecki, P64800 on behalf of Mr. Running. Mr. Running, please state your name for the record.
Jeremiah James Running.
What's your pleasure, counsel?
Your Honor, I'd like to set this for preliminary examination, please.
All right, the court will continue to plead not guilty and set this matter for preliminary examination. It's due March 27th at 9:30.
Judge, I have a sentencing in Frank Murphy set for 9, and then I have exams at 11 and 11:15 before Judge Sabri. Is there any chance we could be maybe 11:30 or 11:45?
About 10:45.
That's fine, Judge. That shouldn't be a problem.
All right, March 27th at 10:45, bond will be continued.
Thank you, Your Honor. Mr. Runnings,
Thank
you're
you.
all, excuse me, Mr. Running, you're all set, and we'll talk later.
Sounds great. Thank you, Mr. Konecki.
Thank you. Have a good
Thank
day,
you,
everybody.
Honorable Judge King.
All right, have a good day, sir.
You too.
Ms. Birchback.
Good morning, Your Honor. I have Mr. Hunt. He should be in the waiting room.
I don't have a Hunt in my waiting room. I have a Tina Livingston and I have someone on iPhone.
I will double check with him what his name is. He told me he's been on for a while.
Livingston in the waiting room of Livingston. That's for Cameron Bradley. Next to the.
Oh, that's the attorney?
Yes.
Ms. Livingston,
Yes, Judge, good morning.
you have to let me know that you are in fact an attorney. I had no idea.
Judge, I didn't know how to set my name properly. I tried to do it last night. I apologize.
So wait a minute, when did you join the defender's office?
I'm not with the defender's office. I'm the prosecutor, Judge.
Oh, okay. I was about to say.
You think I switched sides?
thought
It's been
you
almost,
did.
it's been
I haven't
almost
seen
20 years.
time. I know, where you been?
I'm still with the office, Judge. I don't do trials too often anymore, but I'm gonna handle this case.
What you doing?
What's that, Judge?
What do they have you doing?
I do the VCRI unit now,
What's that?
Violent Crimes Reduction Initiative for all the homicides in Wayne County, in Detroit. I apologize.
What does that entail?
We do all the warrants for homicide.
Warrants?
We do all the warrants, Judge. I'm old now, Judge. I'm old now. I need a break once in a while.
You're a litigator.
I know I am, Judge. I know I am. I must be in your courtroom, that's for sure.
Who do I need to talk to? That needs to be-
Yeah, you're gonna end up talking to me if you talk to somebody.
All right. So, Ms. Birchback,
Yes, Your Honor. He told me he's on. I'm not sure what to make of it.
is this him on the iPhone?
Potentially, he said he doesn't know what his name is on the Zoom. I just sent him the link again to try to make sure he's on the right link.
Hold on, let's see.
Mr. Hunt, is that you logged on the iPhone there? You're on mute, but we can see that someone is logged on, but your video isn't on.
Okay.
There we go. Is that you, Mr. Hunt?
Yes.
Okay.
Okay, we're ready on that.
Calling case number 240-55809, the people of the state of Michigan versus Kenneth Hunt. Defendant is being charged with count 1, assault with intent to break out of car, less than murder or by stipulation. Count 2, weapons, firearms, reckless use. Habitual offender for defense notice. Today is the date and time for probable cause and appearances.
Judge, I am not the prosecutor for Mr. Hunt. I'm the prosecutor for Mr. Miranda.
And I'm the prosecutor for Mr. Hunt. So
Okay,
good
I
morning, Your Honor.
apologize.
Shelley Drain for the people, P number 60249.
And good morning, Charlotte Birchback from the Neighborhood Defender Service, P number 86740 on behalf of Mr. Hunt, who is present on the Zoom. Mr. Hunt, can you say your full name for the record?
Akil Renard Hunt.
What's your pleasure, Ms. Birchback?
Your Honor, we have received all paper discovery. I do not have digital discovery, so I'm just asking that that be passed and we're ready to set for exam.
I'll send it.
Thank you.
The court will continue to plead not guilty and set this matter for preliminary examination housed March 27th at 9:30.
I believe I have to be in person in Romulus that day. I could do later that morning. Otherwise, any other day next week is better.
March 27th at 12 o'clock.
Yeah, that should be perfectly fine.
Okay, March 27th at 12 o'clock, bond will be continued.
Thank you, Your Honor. Mr. Hunt, you can log off and I'll give you a call.
Okay.
Ms. Livingston.
Yes, Judge, I apologize for that.
Did you change your last name too?
Yes, I did.
So you're trying to fool me.
Well, I decided I have to get married once, you know, so.
Well, congratulations. My invitation must have got lost in the mail.
I did a backyard wedding, Judge. I'm not fancy, you know, but you're always welcome anytime, that's for sure.
All right. So do you know who the attorney is on your case?
I do not. I was told on the Register of Actions that it was the Defender's Office. I have called there 2 times, once last week, twice this week. I have not received a call back.
Okay. Mr. Anderson.
Good morning, Judge.
Good morning, sir. What can I do for you?
I'm here on the PCC for Denard Owens. I think we're just waiting for defendant. He's currently incarcerated at Wayne County Jail. We had spoke about it this morning.
I see. That's right. His attorney said they were going to wait. Can we call the county jail? I have an officer here.
Yes, I got you.
We call the county jail and see if we can get Owens before county.
Yep.
And I think we're calling the defender's office now to find out who's on Miranda.
Thank you, Judge.
I wonder if Miranda was giving Miranda one.
No comment, Judge.
Yes.
Yes, sir.
He's on the mental health floor. They're trying to get him down to the camera.
Okay, thank you. Appreciate it. Mental health board.
Yep.
concern is, but they're not answering, they're going straight to voicemail, so I'm gonna call and see if they can possibly get another.
Okay.
I'm trying to find something.
Okay. Who is? Simon?
Yes.
Maybe we can call someone else from the defender's office. They can look at their system.
They told me who it belongs to, but when I called, they told me she's not answering. She's
Oh,
all
who
straight
is
to
it?
voicemail. Lisa Frederick.
Who are you folks here on? Good morning.
Yeah.
Oh, okay. Gotcha. Mr. Harris, good morning, sir.
Good morning.
What can I do for you?
How are you?
Doing good.
I,
Oh, you're here for my 9 o'clock.
I'm here for your 9 o'clock, Judge. I'm
Only 16 minutes late.
only 16 minutes late.
I approve.
That's a good thing. I'm cruising. Let's see. Yeah, Tamika Crawford. I know my client's out there. Where's the prosecutor? She's out there. Okay.
So apparently Lisa Frederick is the attorney on the Aaron Miranda case. We haven't been able to reach her though.
Okay, Judge.
Your Honor.
Yes, sir.
Your Honor, with the court's permission, may I speak?
Go ahead.
Thank you, Your Honor. Your Honor, I had the opportunity to speak with Mr. Anderson, and while we were waiting for my client to be brought down, we had some reservations about his competency to stand trial and proceed with these matters. I had spoken with him, and Mr. Anderson had expressed similar concerns. Obviously, he can speak for himself, but we wanted to bring it to the court's attention.
So what do you want me to do?
Mr. Anderson?
Yeah, so Judge, I guess, I don't know how the court wants to proceed. I think defendant intends to waive the preliminary examination, but I think if we have competency concerns, I don't know how the court wants to proceed. If you want to, think we should proceed with a referral to competency prior to the waiver. You know, I think my opinion would be that would probably be the proper course.
There's some issue as to his competency. It doesn't make sense for me to take his waiver. He has to be.
Absolutely, Judge.
Doing it. So you want to refer him for a competency evaluation?
Yes, Your Honor, if the court would allow that.
I think that makes sense. Let's make sure that he's competent to understand what's going on.
Of course, Judge.
Because they don't do the responsibility of the exam station. All right, so let's do. Are you willing to waive the defendant's presence for the?
Yes, Your Honor.
Okay, we're ready on Denard Owens. How you doing,
You're welcome. Calling case number 240-561-16, the people of the state of Michigan versus Denard Owens. Defendant is being charged with count 1, reckless driving, causing death. Count 2, failed to stop an accident when at fault resulting in death. Count 3, operated under influence, leading causing death. Count 4, reckless driving, causing serious impairment of body function. Count 5, operated under influence, liquor causing serious impairment. Today is the date and time for a probable cause.
Good morning, Your Honor. Jaron Anderson on behalf of the people, P85434.
Good morning, Your Honor. Yvonne Parabon Keller, P84328, appearing on behalf of Mr. Owens, who, for the purposes of this hearing, has waived his appearance.
Court will waive the defendant's presence. What's your pleasure?
Your Honor, having had the opportunity to speak with the prosecution regarding reservations that we have shared as to the competency of the defendant in this case, we ask that he be referred for an evaluation at this date and time.
All right, I will refer the defendant for a competency evaluation. We'll set a review date for June 20th, 2024 at 8:30 a.m. We continue.
Thank you, Your Honor. And the date of the review date?
June 20th.
June 20th. Thank you.
Thank you, Your Honor.
Okay.
Thank you, Mr. Anderson.
Thank you.
There she is. So you
I've
came
been
in
in and
person,
out.
huh?
Yeah, I've been in jail. I got an exam.
Oh, okay. Yes, we need you for.
Mr. Miranda,
Yes.
so glad because I was gonna have to log on to do the PCC with you in the hallway, and that's just hard.
Okay. We're ready on the right.
Okay, I am too. Is he online or in person?
He's not here.
Okay.
Calling case number 230-60543, the people of the state of Michigan versus Aaron Miranda. Defendant is being charged with count 1, delivery of controlled substance, on the left. Count 2, controlled substance, delivery, manufacture, cocaine, around or another narcotic less than 50 grams. Count 3, weapons from the firearm. Today is the date and time for probable cause. Please.
Good morning, Judge Kane, Tiana Livingston, on behalf of the people.
Morning, Judge Ryan. Judge Lisa Frederick, P53372, appearing on behalf of Mr. Miranda.
All right. And are you waiving Mr. Miranda's presence for the purposes of this hearing?
I would need to waive his presence, Judge Ryan.
Court will waive the defendant's presence. What's your pleasure?
I would like to set this matter for an exam.
The court will continue the plea of not guilty. We will set this matter for a preliminary examination. I was March 28th at 10 o'clock.
Judge, I believe we did have the exam set for the 26th, if I'm not mistaken. I would like the court to be aware that while we have sent our subpoenas out last week, I have been notified by the officer in charge that one necessary witness of the 5 to 6 that I intend to call has a pre-planned vacation and will not return till April 2nd. I would like to speak with Ms. Frederick and figure out if that's a witness that can be stipulated to so we do not hold up this court. But I did want the court to be aware.
You didn't offer proof as to what that witness would testify to.
That witness will testify that it's his job as an expert to forensically extract the cell phone data from the defendant's phone. That information will be necessary as the court is aware that IMEI numbers are connected to cellular devices. That cellular device will be very important to the people's case in chief.
Ready?
I would like to speak to her because I'm not inclined to just stipulate off the cuff like that. We can discuss it. April 2nd, Your Honor, I'll be in trial.
I have not been notified. I have not been notified that any other witness would be unavailable, but I sent subpoenas out for the 26th as that's the date that I was notified of. So I cannot tell this court if there would be a different conflict with another witness or not.
I'm available on the 28th or 26th.
You're gonna call that many witnesses on the 26th. That's not gonna be doable. I can do the 28th at 10 o'clock. I have a 4-defendant preliminary examination on the 2nd. Are you available on the 4th, Ms. Frederick?
I have the Gilmore homicide April 1st. So I'm thinking I'm gonna be tied up the whole week.
I will say the witnesses I anticipate the call, Judge, will go very quickly.
That's what they all say.
Well, it depends on what I'm doing too.
I understand, Judge. I'm just letting Your Honor know that these witnesses are, for the record, Judge.
We can try the 26th at 11:30.
And this is the day her witness can appear, correct?
That is the date that one witness will not return until April 2nd.
Your witness be available via Zoom?
He is out of town, Judge, for that week. He has a prepaid vacation planned with his family. And I could ask, I could ask him for sure. I'll find that out in the next hour. So I'd like to speak with Ms. Frederick because I do believe that it may be a witness she would be willing to stipulate to.
I'm in between, I've got an exam coming up, as I indicated, right next door. So if you want to call me, that's fine. We can talk.
Of course.
They can call me right now.
Okay, she's about to go into an exam right now. But I'll leave it to you guys to get together and see what you can work out. Okay?
Yeah, I do not have Ms. Frederick's phone number. I'm sure someone in my office can help find it for me.
I don't mind giving it to you now. Do you want it?
Oh, yeah, if you don't mind, sure. Absolutely.
313-569-9584.
313-569-9584.
Yeah.
Thank you. Thank you.
You all set, Judge?
Yes, thank you very much.
Thank you.
No. For the family of the
Oh.
Thank you, Your Honor. It's a pleasure seeing you again.
Thank you. Have a good day.
You too.
So I think we need to call James on Pollard. And Mr. Harris. Yes, sir. You have a question?
Yeah, I just wanted to, check that I heard 26.
26 at 11:30. Yes.
Thank you very much, Your Honor.
Okay, thank you, sir. Have a good day.
Thank you.
Check on Mr. Harris.
Mr. Harris was talking to his client, consider waiving.
Okay. Yes, Mr. James. Good morning, Ms. James.
Good morning, Your Honor. How are you?
Good. Yourself?
I'm good. Multitasking this morning.
You're here on Pollard, correct?
Yes, Your Honor.
You know who my APA is on that case?
Oh, they were asking Shelly Drain to stand in. It's Erica Moses, but she's in jury trial.
Okay. There she is. Ms. Drain, I have Ms. James here on Pollard. That said you were standing in for Erica Moses.
Yes.
Okay. Ready? All right, ready on Pollard.
Calling case number 240-55381, the people of the state of Michigan versus Kevin Pollard. Defendant is being charged with count 1, criminal sexual conduct, second degree. Person number 13, defendant 17 years of age or older. So a notice to the is to make time for
Please remove your sunglasses.
appearances.
Appearances for the record, please.
Good morning, Your Honor. Shelley Drain for the people, number 60249.
And good morning, Your Honor. Nicole James, appearing on behalf of Mr. Pollard. Judge, I would ask to waive his presence if he is not in the courtroom. He is in the Wayne County Jail.
Court will waive the defendant's presence. Today's the date time set for a competency hearing. Did we get anything back from the forensic center?
Yes, Your Honor. The report indicates that Mr. Pollard is competent.
Are you stipulating to those findings?
I am, Your Honor.
Okay, the court makes a finding that the defendant is competent to stand trial. What's your pleasure?
Judge, we would ask that it be set for a preliminary examination date.
Court will continue the plea of not guilty and set this matter for preliminary examination. How is March 27th at 12:15?
Judge, I'm out of town all next week. My first available date would be April 4th.
That's gonna be a problem, Ms. James, because the court is, that's my homicide day, the court is closed. Good.
Okay. Well, Judge, I'm out of town all next week, and then April 1st, 2nd, and 3rd, I'm in a trial in Ann Arbor.
April 8th, that's my last offer.
April 8th is a good date.
April 8th at 10 o'clock.
10 o'clock, yes.
Bound to be continued.
Okay. Thank you, Your Honor. Have a good one, everyone.
Offers away. Wow.
All right. Morning, Wayne County. Who do we have here? What's your name, sir?
Owens.
One more time.
Owens.
Mr. Owens, okay, Mr. Owens. In waiting for you, we went ahead and handled your matter. You have been referred to the forensic center. They want to make sure that you understand everything that's going on, okay? So I'll see you back again on June 20th. Gonna have some doctors come and talk to you, make sure everything is okay, that you know exactly what's going on and that you can help your attorney in your defense, okay?
Okay.
So you're all set, sir. Have a good day.
Okay.
Calling case 2359851, people of the state of Michigan versus Tamika J. Crawford. Defendant is charged in count 1, weapons, firearms, possession by felon. Count 2, assault with a dangerous weapon. Count 3, felony firearm. Count 4, domestic violence. Defendant has a habitual offender court offense notice, mandatory 25-year sentence. Appearances for the record.
Good morning, Your Honor. Shelley Drain for the people, number 60249.
Good morning, Your Honor. Wyatt Harris, P54891, on behalf of Tamika Crawford, who stands to my left.
Tell me your name for the record.
Tamika Crawford.
There's a date and time set for preliminary examination.
I discussed with Ms. Crawford her rights during the examination. She understands those rights, Your Honor. However, she wishes to waive those rights. And I believe before you was executed.
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You understand you have a statutory right to have a preliminary examination. By waiving the same, it means you won't have one. You will be bound over to the Wayne County Third Circuit Court as you stand in charge of point one. You understand that?
Yes, sir.
You understand the nature and the purpose of the preliminary examination?
Yes, sir.
You understand if you were to have one, the prosecution would have to establish that the crime you're charged with was committed in the city of Detroit and it was probably publicly you committed.
Yes, sir.
Is anyone forcing you to waive your right?
No, sir.
Does anyone promise you anything?
No, sir.
Are you waiving your right freely and voluntarily?
Yes, sir.
Any objection from the people?
No objection, Your Honor.
Court finds the defendant's waiver is made knowingly and voluntarily free, therefore the court will therefore bind the defendant over to the Wayne County Third Circuit Court. Criminal provision for the proceedings. Her arraignment on the information date and time will be April 3rd, 2024 at 9:00 a.m. Father, we continue.
Thank you very much.
Thank you, sir.
See you on the hall. First, you have a good day.
Thanks, you too. Don't be such a stranger, man. Have you
Yeah, man. It's been a minute, but you know I had a little surgery.
No, I did.
Surgery on my back in December. So,
What? You let somebody kill me?
yeah,
On your back, how you feel?
I'm feeling okay. I'm finally getting around.
Back to deadlifting again?
Oh, you're right. 800 pounds.
Oh, okay, good, man.
That quarterback in Philadelphia.
All right. How you doing?
See you now. It took up my cold.
Oh. Thank you. Great. March 3rd at 11:05.
Is that March 3rd?
Yes.
I'm sorry.
I'm sorry.
April 3rd. April 3rd. I'm sorry.
Okay, hold on, wait a minute. March over with.
One last thing, Jimmy. Yesterday, we had a case where Sharon Taylor.
That's Juneteenth. That was when I couldn't find my phone.
And no, that's my fault because I should have called that. So
So let's put that up to 20.
That's all.
Notify the attorney.
Well,
I just saw that. So, for today. Is that Bobby D?
yes, it is.
Hello there, Bobby D. How are you?
I'm good. Did you get the information?
No, what information?
May I?
Yes. Okay.
Yeah, so she's gonna. So maybe I'm gonna. Okay. Judge, this is Attorney Kopowitz for Smith at 10 o'clock. She said she's at another court. She's running about 15 minutes late. Is that okay?
Ask the witness. Hey, now, how you doing?
Judge, how you doing?
All right, what's going on?
Pretty good, hanging in there.
Mr. Harris here? Sorry, not Mr. Harris, Mr. Noakes. He's usually on time.
So many.
Watch you.
Thank you. So that's oh.
No, it's that.
So the happiest time at, so that case was on Monday, but that was for the competency violation, due back June 23rd. Well, if you did Monday, you scheduled it Monday, you can do it for 2 days.
Mr. Noakes, how are you doing today?
I'm doing very well. How are
Good.
you, Ron?
You ready? Look like you just stepped off Wall Street. Very business-like.
Oh, now I did have encounters with Wall Street early in the career.
Did you really?
I was with the SEC.
Okay.
Yeah, I was with the division.
Sure.
Very early. My client is indicating he's going to wait. So once I get the waiver, we'll be out and discuss it.
All right, here's the file. Your client is the target?
Yes.
Thanks, sir.
This one is from today, last one.
Oh, yeah.
Good morning, Your Honor.
Good morning, how you doing?
I'm on my way.
Sir? Yeah, Parker. Waiver.
That's great.
Notes? Yeah, you already got it. You already got it. Okay.
Thanks, sir. Case 2455801, people of the state of Michigan versus David Hardrick. Defendant is charged in count 1, criminal sexual conduct, first degree personal injury. Count 2, criminal sexual conduct, first degree personal injury. Count 3, criminal sexual conduct, second degree personal injury. Defendant has a habitual offender court offense notice, mandatory 25-year sentence. Appearances for the record, please.
Good morning, Your Honor, to your staff, Chairman Solari, number 86651 people.
Good morning. May it please this honorable court, William Morris, P42796 of the Neighborhood Defender Service of Detroit, on behalf of Mr. David Hardwick, who is present before you. Please tell the judge your name.
Sir, my name is David Hardwick.
There's a date time set for preliminary examination. Mr. Notes.
Your Honor, having reviewed with Mr. Hardwick, either having an exam or waiving the exam, Mr. Hardwick has decided to waive the exam.
Please raise your right hand, sir. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do, sir.
Thank you, sir. You understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one, and you'll be bound over to Wayne County Third Circuit Court as you stand charged.
Yes, sir.
You understand the nature and the purpose of the preliminary examination?
Yes, sir.
You understand if you were to have one, the prosecution would have to establish a crime in charge with this committed in the city of Detroit, and it's probably cause to believe you committed it.
Yes, sir.
Is anyone forcing you to waive your right?
Yes, sir.
Has anyone promised you anything?
No, sir.
Are you waiving your right freely and voluntarily?
Yes, sir.
Any objection from the people?
No, Your Honor, no objection.
The court finds defendant's waiver is made knowingly and voluntarily freely given. The court will therefore bind the defendant over to Wayne County Third Circuit Court, Criminal Division for the proceedings. His arraignment on the information date and time will be April 3rd, 2024 at 9:00 a.m. The revocation testify.
Yes, Your Honor. I would simply ask, he's been on house arrest. He's been released on a Tether on house arrest for your order. I'm asking that he be given hours for work.
What is he work?
Robert Rowland's demo construction company.
What is it again?
Robert Rowland's, number 2.
Spell that for me, Robert.
Robert, and then ROBERT, Rowland's, ROWLINGS. Telephone number is 248-747-0529.
747-0529.
Yes, he's on my Tether paper too, sir.
How long have you worked there?
About 7 years.
What do you do?
Belle Isle, the bar place, do a bunch of.
I'm sorry, I didn't hear you.
From Belle Isle to the bar place, he owned a bunch of properties, a bunch of houses.
My question was, what do you do?
Demolition. Bring it up.
Tell him what he does, Mr. Jones?
No, Your Honor, I just wanted him to be clear. He's already told me that he does demolition, but he was giving his words to me.
What does demolition entail?
From breaking out walls to knocking down abandoned houses to rebuilding, from drywall to cedar floors to roofing to everything.
When was the last time you worked there?
Right before I got locked up there. I work every day. I worked on the 8th.
Name of it is Robert Rawlings, what?
Robert Rowland's Construction Company. Gave his number, like I said, he's on my Tether.
Where's that located?
He stayed in Novi, but
is this a real company, sir?
yes, it's a real company. Yes.
And you say it's ROLLINGS?
ROWLINGS.
Yes.
People haven't left to take that.
Okay.
Your Honor, the people would strongly oppose defense counsel's request. The allegations here are heinous. The victim, Samantha Joe, she's present today. I'd like to say the name of the record. Your Honor, after reviewing the report and speaking with her, the assault that took place happened over the course of hours, including multiple beatings, multiple penetrations. Not only that, Your Honor, this defendant has an extensive assaultive criminal history. So people would strongly oppose being released on tether for work hours and actually be asking for remand.
What is his original bond?
That was my understanding.
His original bond was remand?
Yes.
And due to my apologies.
Go ahead.
Your Honor, all I'm asking is that he be allowed to work and given limited hours, and it would be necessary, no contact with the complainant in this case. It's unfortunate that these allegations have been made, but to have him at home without the ability to work, he may not be in a home very much longer.
Well, that was about to be my point that I was just about to make. If these allegations prove to be true, he doesn't have to worry about being home or going to a job. Because for the next few years, that wouldn't be a concern because he'll be in prison. This court originally reduced his bond because there was some kind of delay. I think the complaining witness was not available.
No, Your Honor, it was actually failure to turn over the discovery that I needed for the exam.
What was the discovery?
And the discovery was essentially a telephone bill, which I did receive and I've gone through it. And the whole issue is, I believe that these are allegations that will be proven false at trial based upon the nature and character of the complaining witness. My client has decided to waive the exam and go across the street. All I'm asking for is the opportunity for him to work until such time as this case comes to trial.
I haven't been able to substantiate that this is in fact real employment. There is no rolling construction that I can find.
Your Honor, if I may respond to counsel notes.
Go ahead.
Counsel notes. So first, it wasn't a failure to turn over, Your Honor. We were not in possession of the phone. We had turned everything else over. On the morning of the exam, which was last week, and I was present, the victim was also present. We turned it over then. And since then, it's my understanding that AK Warren had attempted to provide him with the phone dump, which was at this point, I believe, turned over to him. That's the first part. The second part would be, it's not just allegations, Your Honor. Looking at the discovery, watching, which has been turned over to counsel notes. The body cam, there is physical evidence. She was covered in bruises all over her head, just observing that within the day that she was taken to Beaumont Hospital.
I have a question for you, Mr. Harvey.
Yes, sir.
If I was to have you drug tested right now,
Yes, sir.
would you test positive?
No, sir.
You sure about that?
I have smoked weed, but yes.
That's a drug.
Okay,
You
but,
recognize that, right?
I have a, yes, I have a recreational card too.
I'm sorry?
I have a card.
You have a card.
Yeah.
So why are you smoking weed? For what reasons?
This was vague, this was weeks.
I'm asking, what's your condition where you have to smoke marijuana?
I go through chemotherapy. I haven't been through chemo lately
Why not?
because of being incarcerated. So far.
You have cancer,
So,
lung cancer, and you smoking marijuana?
Ron, it's often known to be a palliative for someone who is in pain. And he has essentially a prescription for it. And all I'm asking for is.
I know exactly what you're asking for, Mr. Brooks. That's clear. My concern is whether or not this defendant poses a danger to the community. I'd like to know what he's doing all this out. So I was thinking he's smoking weed, but he's smoking weed because he has cancer. And then on top of that, he has lung cancer. That doesn't necessarily make a lot of sense.
Your Honor, sir, I do respect what makes sense. I will beat this case trial. I'm not thinking about 58. I don't have no time, but I would respect if you could. I appreciate that. So I can have some kind of income. Other than that, I'm not thinking about the victim and none of that. All these allegations. And I'll speak freely. I have crystal meth happen. So I know all about it. I'm just trying to keep myself on the right path.
So you would test positive for marijuana, anything else?
No, sir, nothing else.
Last time you smoked marijuana was when?
Thursday, last Thursday. We're ready to take a test right now.
Okay, so there are a number of factors that the court is considering, one of which is the likelihood of conviction. And I don't know what the likelihood of conviction is, up to the assistant prosecutor determined to look at it. Something about there being video, victims, injuries, and so forth. I also consider the defendant's criminal history. It appears to be rather extensive. However, much of his criminal history dates back a little over 10 years. These are very serious offenses. And the defendant is looking at these 25 years to life. This court cut the defendant a tremendous break in reducing his bond because discovery could not be complied with at the time matters officially scheduled in the examination. This court also has to consider the potential danger to the community that the defendant presents. The allegations here, in addition to his criminal record, are rather troublesome. Check one last thing.
Your Honor, if I may clarify for the record.
Go ahead.
So from the body camera of the officer who was at the Beaumont Hospital, what that responding officer would see is bruises within the day after the assault, bruises all over her head. There's another officer as well. They lift up her shirt and they observe the injuries to her back. That is not what the camera view, but they observe the injuries to her body. So what is in camera view are the injuries to her head.
And Your Honor, there is nothing to say that those injuries did not come from some other source. So, given the nature
So
of
you're not telling me that she's making it up. She
Oh,
got it from some
I
other
would-
source.
I would never
and then
tell
blame
you
it on
that
the
something
defendant.
has been made up, Your Honor. But what I'm asking you is to simply take into consideration the fact that my client is willing to proceed to the Third Circuit to defend against these claims.
You won't get an opportunity to do that regardless of what I do to the crime.
Really, Your Honor, this man is a veteran of the United States Marine who served honorably for 6 years and was honorably discharged. I would ask you also to take that into consideration. He knows how to follow orders.
But does he know how to follow the law? His criminal record would suggest otherwise.
Your Honor, given that those offenses were more than 10 years ago, I would say that little consideration should be given to them at this point in time. And I'm simply asking that he be allowed to work.
Your Honor, the people aren't even really clear what his employment is. What is demolition? Where does he work? It's a bit concerning.
It is for the court too. That's why I asked the information that I asked. I'm just looking. Him giving me a phone number, but it doesn't mean nothing. Because people can say, hey, I'm gonna have the court call you.
You look up.
Let me tell you what it is.
Your Honor, my client was informed that if you look on the internet, you find constantly Owens as the overarching name of the company that he works for.
Constantly rolling.
Yes.
I don't see anything of that. I punched that up. I didn't burn on my green line. It's not. I get six construction. Rationale. Nothing. Okay, what's the number of this guy?
Serves on 248
747-2529.
0529, sir.
So 0529. What's his name?
Robert, you call him Jake.
What hours do you work, sir?
Between hours, 8 o'clock till 4 or 5 o'clock in the afternoon.
Okay, so people, you do understand the purpose of bond is not for punishment. It's to ensure that the defendant appears for court, which I don't think we have an issue with, because he's on the tether, he's appeared to court here today. As far as I know, he hasn't missed any court days. The other part of that is that he doesn't pose a danger to the community. His prior convictions are from the 90s, 1994, 1993. Has one from 2008 controlled substance.
The people do understand that bond is not served for punishment. People will just highlight that the victim is here today, and she is so afraid that she's not even sleeping in her own home. And within the community, we went by alter egos such as super cred. So that's what the investigation has turned out. So people's concern here are potential gang affiliations as well as fear of victim. And I understand that his previous history is from 20 years ago, but we don't know. All we know is the allegations that are set forth in the police reports, what the victim has told multiple times to the prosecutor's office, to the police officers, and during her sexual assault exam.
Where did you get the name Supergrid?
Your Honor, that is a name that appeared during the OIC's conversation with the victim during during a separate at Beaumont, which was during her sexual assault exam on February 15th, 2024, and then afterwards her interview with the officer in charge, Detective Buchanan. There were also other names, Your Honor, but
Has there been any contact?
I'm sorry, Your Honor?
Has there been any contact?
Well, Your Honor, he's been in remand, and I haven't spoken with the victim as to whether he's contacted her from jail or within the past week, whether he's contacted her, because she has moved and she changed her phone number.
The client has not contacted her, and he's done all that he expected of him when he was on house arrest. He did what he's supposed to do. He's here today as he's supposed to be. Oh, and I don't know if the prosecutor has seen the video that Snoop Dogg called Soup. That may be where they came from. Again, it's a matter of, can he work? Can you limit the hours so that he can earn some income? And if you want to put him on house arrest, otherwise, I don't see a problem. But he does need to work.
I'm going to have the defendant drug tested to see if he has anything besides marijuana in his system. Right? So you just bet your freedom on that, sir. We'll see what it comes.
When should we be back?
He's going to stay with me.
No, I understand that. I'd like to be present when the results are. I have an exam in Sturge at 11.
I think it takes some time.
You should have your clerk call me. I should be done in Inkster in about an hour. And then I can come back.
let's say 12:30. 12:30?
12:30 or 1, depends, because I've got to get registered. It's roughly 20 minutes there and 20 minutes back, and probably an hour for this season. So I have a meeting. So I have a meeting at 1:05. Shouldn't take very long. So should I come back after the meeting at 1? Yeah, let's say 1:05. Okay. That way I know I will be supposed to. Okay. Calling you to say. All right, thank you. So I'll decide one way or another, depending on what comes back on the process. Thank you. Okay, thank you.
Thank you.
And rest assured that the court is going to do everything it can to make sure that there's no contact whatsoever, okay? Whether he's in jail or otherwise, whether the house is in jail or whether the Wayne County jail is in jail, he won't be contacted, okay? Geraldine Smith. Archer. Yes. Calling case 24-56079, people of the state of Michigan versus Geraldine Annette Smith. Defendant is charged with count 1 assault with a dangerous weapon, count 2 domestic violence. Appearances for the record, please.
Good afternoon, Your Honor. Rachel Elliott on behalf of the people requesting permission under Michigan Court Rule 8.120B under the supervision of Attorney Shelley Tree.
Permission granted.
Neighborhood Defender Service by Jackie Pilkowitz, P81653 on behalf of Geraldine Smith, who stands to my left. Ms. Smith, will you state your name for the judge, please?
Geraldine Smith, how you doing, Your Honor?
Doing well, thank you. How are you?
I'm
Good, thanks. So today's the date time set for preliminary examination. Are we ready to proceed?
We are not, Your Honor. The complainant was notified of today's date and time for the hearing. However, they are not present and we cannot proceed without their testimony.
Your Honor, I move for dismissal without prejudice this time.
So order, the court will dismiss this matter without prejudice.
Thank you.
Thank you, Your Honor. Mr. Thompson.
Brandon Thompson. Calling case 24-55912 for the state of Michigan versus Brandon James Thompson. Defendant is charged in count 1 home invasion, first degree, count 2 domestic violence. Appearances for the record.
Good morning, Your Honor. Madison Oro on behalf of the people requesting permission under CR 8.120B under the supervision of Attorney Shelley Tree.
Permission granted.
Neighborhood Defender Service by Jackie Pilkowitz, P81653 on behalf of Brandon Thompson, who stands to my left. Mr. Thompson, will you state your name for the judge, please?
Brandon James Thompson.
There's a date time set for preliminary examination. Are you ready to proceed?
Your Honor, the complaining witness in this case was notified of today's date time of the preliminary examination, and unfortunately, they are not here, so we are unable to proceed.
I I would move for dismissal without prejudice, Your Honor.
So, or court will dismiss this matter without prejudice.
Thank you. Judge, I was telling Mr. Thompson that I wish all of my clients would dress this nicely for court.
I do
He
too.
did. Yeah.
All right, is Ms. Schultz here?
Have a good day, everyone.
Thanks, you too.
Judge, you would like to step out to testify.
Yes. Good morning, folks. Hey, Jim. What can I do for you? What can I do for you? What can I do for you? Okay.
John, you done with paperwork?
Yeah, so you can send him up, you guys have to take Mr. Harper's number.
Yeah, okay, yeah, he's right. Yes. I'll send you to, I'm in addition to that, that's all we're gonna set stuff. All right, bye. So this is the order. She asked me, do we have an order? This is.
Yeah, they just said that.
I never did.
I'm still working on that. I know y'all got here.
Where do you take it to? I don't even know, I'm curious.
You know, it's like an end of that program. Yeah. You know, the elevator just go right.
Learn something new every day.
Yeah.
No custody, he's really not in custody right now. I'm sure it will. Thanks, sir. No. Made my job. When you walked in, I'm like, yeah. She's on the way up. Sure. Yeah.
Gotta make people approach.
Yes. Ms. Dixon, you can approach too.
Hey.
Yeah, wait. I have like.
Name it Oh, yeah, she the last case. They got started yet. They're trying to watch it.
Y'all have already dead. I'm jealous. Going through couple.
Yeah, they're the ones that are making me go like that. Thank you. Thank you. Your Honor, yes, here via Zoom or should I be in person?
If you want to be in person, that's fine. If you want to come via Zoom, that's fine too.
Okay, thank you, Your Honor.
Do you have anybody here on the show?
Everybody on Shepherd?
That's Ms. Shepherd back there, right?
Yep.
Yes.
I told them to call us with the results. Don't tell him because he might try to run out the door.
Yeah. He needs to be escorted back.
Yeah. That'll just go away. Excuse me. You looking over?
I think we need just one more minute.
I'm gonna ask the judge to actually do it.
what.
Okay, thank you.
Yes, no?
It's gonna be a waiver.
Okay, come on. It's gonna be a waiver, sir.
Okay. Counsel Carisha Shepherd. Calling case 2456094. People of the state of Michigan versus Yasa Carisha Shepherd. Defendant is charged with count 1, assault with a dangerous weapon, count 2, felony firearm, count 3, domestic violence, second offense notice. Domestic violence and or knowingly assaulting a pregnant woman, second offense notice. Appearances for the record.
Good afternoon, Your Honor. Rachel Elliott on behalf of the people requesting permission under NCR 8.120B under the supervision of Attorney Shelley.
Permission granted.
And good morning, Your Honor. Alexander Cho with the Neighborhood Defender Service P85948, appearing on behalf of Ms. Shepherd, who is present in court. Shepherd, can you see your name? Yes, Shepherd.
Yes, I'm sorry. Today's the day and time set for preliminary examination. Are you ready to proceed?
Yes, Your Honor.
Your Honor, after speaking with Ms. Shepherd, we will be waiving today's exam.
Ms. Shepherd, please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, ma'am. You understand you have a statutory right to have a preliminary examination. By waiving the same, that means you won't have one. You will be bound over to remain coming before the court as you stand charged. You understand that?
Yes.
You understand the nature and the purpose of the preliminary examination?
Yes.
You understand in order to have one, the prosecution will have to establish the crime and charge with what's committed in the city of Detroit, which is probably cause of the individual.
Yes.
Is anyone forcing you to waive your right?
No.
Does anyone promise you?
No.
Are you waiving your right freely and voluntarily?
Yes.
Any objection from the people?
No objection, Your Honor.
The court finds the defendant's waiver is made knowingly and voluntarily freely given the court and therefore binding to the notice of Wayne County Court Circuit Court. Criminal Division of Proceedings. Her arraignment on the information date time will be March 27, 2024, 9:00 a.m.
Your Honor. Oh, excuse me, if at this time we could address bond for Ms. Shepherd.
I'm sorry?
If at this time we could address bond for Ms. Shepherd.
Go ahead.
Your Honor, Ms. Shepherd currently has a personal bond with the GPS tether requirement. And I believe that Ms. Shepherd had initially spoke to somebody from the tether office and attempted to provide them with her information of the address as well as contact information so that that address could be verified. She has not heard back from the tether office and has been in custody, and I attempted to contact them as well. In his custody, waiting for this tether to be put on so that she can get out of custody. Your Honor, I would ask that her at this point tether be removed or that it be urgently made that her tether is placed just because the amount of time she's been in custody. Ms. Yasa is, or Ms. Shepherd, excuse me, is not currently living with the complaining witness.
Where is she going to go?
She has the address herself, but she had plans to move out 2 days before she was arrested on this case. But if she could state the address for the record so it could be known.
What's the address, Ms. Shepherd?
It's 7291.
Who stays there?
Me and my best friend.
Why couldn't you give your address or that address when asked the first time?
Well, I was actually supposed to move out 2 days later. I didn't have the address at first, so I had to contact somebody to get it. I did explain it to the lady. She told me that she would contact me back, and she never did.
So it's just a matter of them getting in contact with you so you can give the address, is that right?
Yes, this was like 2 weeks ago, sir.
So I will continue the bond. Counsel, when you called the tether office, what did they say?
Your Honor, I was able to eventually, after leaving her voicemails, get in contact with the general tether department, and they had stated that essentially they would get in contact with her to get that information. But it has not been done yet.
So they weren't able to give you a period of time?
No, Your Honor. I did not speak with the tether agent that had been assigned to the case. I was able to get through the general line.
So short of removing the tether, what else can I do to help facilitate this?
Your Honor, I believe because the case is getting bound over, if her tether is not addressed by the time I can investigate the court, but at this point, I believe the only other remedy would be the removal of her tether. The reason I requested it is because she is no longer living at the address with the witness in this case.
That doesn't mean she can't go there.
Yes, Your Honor. And there's additional information that I think could establish that they were not planned, which is that there's already a pre-established agreement. They share a number of children, and this mother there's already been essentially a transportation setup between her 3 children, where anyone as his mother has been, dropping off the children. They have a split down the week custody plan where they live with the children for 3.5 days. Ms. Shepherd is taking her oldest child to live at this new location with her. And I believe if she was to get in contact with the witness or that, I would encourage that if it is brought up, if there is an issue, that be addressed by the court, but I don't expect there to be any issue with this case.
Your Honor, I guess that Tether, I do think that is appropriate at this time. Hopefully it should be resolved quickly in terms of the address, but I don't think
is aware that she is still in custody. And is actually kind of fearful of her getting out of custody because he had not seen her. His statement was he had not seen her done before. And now the allegation is that she played a really good. So he is very fearful. He doesn't want to reach out. We do know that she does have a personal bond with the tether. So we're not asking that we change it all, but just that the tether remains in place. I think that's the most important thing.
I'm not inclined to remove the tether. I do want to check one thing. I thought I saw something here about assaulting a pregnant woman. Here, playing with his name. He's not having the kids.
No, Judge, I'm sorry. It's statutory language. From the information sheet. That's right.
That's weird. Pretty much. Okay.
And Your Honor, I would like to clarify, because I believe I had initially seen it as well, but I believe it's one of those situations where it's a encompassing statute similar to rape, bodily harm, and strangulation, where they fall together, but.
Okay. It just threw me when you said he. Let's talk about children and so forth. Do you have any results back? Let's see who's back.
Sure.
You got results? All right, fine, continue.
Perfect. Your Honor, if I could as well, with her new address, if it could just be placed on the record, but the spelling of the street is 7291 Whitaker, Whittaker Street, and that's in Detroit, Michigan.
Sure. Step this way. So sit on that bench.
Thank you.
Thank you, Your Honor.
Thank you. Well, folks, we're almost done for today. We have one hearing left at 1 o'clock. So court will be in recess till 1 o'clock. Have a good day.
Judge, I almost had my time to shine today in front of you.
Almost. It's coming though. It's coming. I can feel it.
Waiting on you. No, I was telling a lot of can't hold it downstairs at 1 o'clock. We'll send them downstairs at 1 o'clock. Judge.
Okay. 1 o'clock is when it's supposed to come back.
Well, 10 minutes to 1.
So you wanna send it back to 10 minutes?
So downstairs to the hearing starts.
Oh, okay.
Yeah. So we can go to lunch.
Oh, yeah.
Yep, that's not. So is that.
Judge, one of the questions I would like to speak to you about a case from the other day. She should be down on this zero.
Any ideas about it?
I think it's about a case from the other day. The attorney wants to address bond. I was so yeah, the GPS, he was supposed to provide work verification, I think, or his hours of work maybe. So we didn't put the bond condition in the system, so I think Harvey just want to find out if we were supposed to do a bond order, or we were waiting for the attorney to submit one. Yeah.
Most likely. Wait.
That's what I thought, because I remember you telling the attorney to provide one, but. Now, if it's- It's for Gabrielle Moore. It was for a non-redetermination hearing on Monday.
Hey, how you doing?
Good, how are you?
Good. I had a question about this case from Monday. Attorney
I did, I'm gonna look at my, if you want to look at this, about the information, he said he was doing the, trying to step in to get the tether for the 22nd. I believe that he was supposed to provide his work schedule. And then the judge, the attorney was supposed to submit an order.
Right.
But I checked the email and I never seen the order, so I created the order, but I don't know if this is okay, or is it, or it's okay. I just did this today, because I know that he's supposed to be by the 22nd, but I didn't know we were supposed to wait for the attorney to submit the order. And I believe that you said that he was gonna, you were gonna contact the Tether union, contact the agency. Yeah.
He's supposed to turn this stuff in private to a Tether.
Right.
Yeah, get that election.
Right. Okay, so I did not need to do this order, sorry, I just put that information in the. Okay, so he hasn't sent it over yet, I don't know if I recall. Okay. Mhm. Okay, so I just put in the system that he just, he has to go there before the 22nd. Okay, by the 22nd, okay, then I'll reach out to the attorney and ask some, about the, okay, thank you. I don't say nothing. Now, I hate to. That's what it was. Right. Yeah. But intention of the bid, I'm just doing. I'm saying you get. And it'll just. Yeah, because but I think it's just easier if you look at if it's your friend. Yeah, that's great. But I think that's just. No, when I was on here. Right. We went on our address. I don't need to say. You don't need me. Right.
Yeah.
Okay.
She do also, I see it. That's not. Okay, man, she like it. Right, okay. I see a little bit, okay. Thank you.
Hi, good.
Hey, how you doing?
Good.
Good.
You guys finished?
No, well, kind, I just have one hearing at 1 o'clock.
Dropping off your gloves. Welcome.
case earlier, the county lawyer said he's competent to stand trial. Do you find this?
Mr. Oaks. Good afternoon. Thank you for rushing back. Appreciate you.
Well, not a problem. Otherwise, I would have had to spend more time with Judge Johnson out there. Oh, but she's.
William Johnson?
Oh, yeah.
Oh, okay. How's she doing?
She's doing all right. I had forgotten that she was the chief judge out of the 27th district. I mean, I haven't been out there, I think, in 20 years, and that was well before she became a judge.
Okay.
So.
Come on, Referral.
Then we were
Stand next to your
all
attorney.
part of that rate page. We were all part of the rate page circle.
Oh. Okay. We're back on the record on case 2455801. That is People versus David Terrence Hardrick. That is before the court on a bond motion. So right before we broke, the court had the defendant drug tested. The defendant indicated to the court that he had not ingested anything but marijuana. This court places a premium on honesty, and it appears as though the defendant was honest with the court. He did test positive for marijuana, cannabinoid, but that's it. Everything else came back negative. So I appreciate that. Let me also say that this is somewhat of a difficult position the court finds itself in because of the normal circumstances. Given this charge, these charges in the defendant's criminal record, this court normally wouldn't think twice about remanding the defendant. But the court also recognizes that the purpose of bond is not for punishment. It's to ensure that the defendant shows up before he's demonstrated that he has a willingness to appear before he appeared timely today, he appeared timely the last time this court was in session. I have no indication that anything else is going to take place. Plus, the court has placed him on a house arrest tether, so he's on tether anyway. In addition to that, although his criminal record does give me pause, the court recognizes that most of his offenses are about 20 years old or older, with one exception, a 2008 conviction for possession with intent to deliver drugs of some sort. Prosecution tells me that they want the defendant remanded primarily because of the strength of their case, which I haven't had an opportunity to review, but also because the complaining witness is afraid. I submit to you that probably 90% of the cases that come before this court, the complaining witness has some kind of fear. That would be normal. This court takes note that this defendant has not tried to contact the complaining witness, has not violated his tether in any form or fashion. And quite frankly, I don't think I have a basis in raising his bond because he's done everything that this court has asked him to do. However, I do take some comfort that he is in fact on house arrest. So we know the defendant's whereabouts, and I'm fairly certain that he's not going to come in contact with the complaining witness. Isn't that right, sir?
Yes, sir.
You understand what's going to happen if you do make any effort to come in contact with her, whether yourself or any third party or anything, right?
Yes, sir.
And you not gonna try to contact her by way of social media, text message, phone calls, or anything, right?
No, sir.
Your Honor, if I may.
Go ahead.
So after the hearing, I came into contact with Detective Buchanan. And as we were outside, we discussed his previous convictions, and she made me aware in that moment, and again, I am covering for APA Moore, that he was arrested on October 24th of 2022 for similar allegations to CSC 1. As soon as I came into possession of that report,
He was arrested.
Correct, Your Honor.
Because this talks
Your
about
Honor,
convictions.
Your Honor, the reason why this case did not move forward is because the victim did not want to participate.
There remain allegations, and it's not a conviction.
You are correct, Your Honor, but from the police's observations of someone mouthing "help me" when they arrive at the subject location is alarming, even though, yes, they are allegations, but they are observations from an officer. And Your Honor, if you want to put aside this, going back to the defendant's statements, which defense counsel is in possession of, he himself talks about having sex with her over a 24-hour period during the work week 4 times, and he says she was incapacitated under the influence of crystal meth as well as crack. So my concern is, what's stopping him from doing this if he is so confident and relaying this to an officer? Stop him from being a threat to the victim. The reason why he's been quiet is because he's been in remand up until last week.
Well, there hasn't been any allegations of him doing anything in that period of time to this period of time, correct?
Yes, my understanding, Your Honor, is that since the victim has changed her phone number and her address.
Your Honor, I can appreciate the zealousness with which a young prosecutor would make an argument. Nevertheless, an allegation is an allegation, and that case never reached a conviction. And once again, if we could.
It doesn't sound like he reached a charge.
No, it didn't.
Okay, so in helping myself out here, the court looks to Rule 6.106 pretrial release, subsection B1. The court may deny pretrial release to a defendant charged with, skipping down to subsection 2, committing a violent felony, and at the time of the commission of the violent felony, the defendant was on probation, parole, or release pending trial or for another violent felony. None of those meet this defendant. Or B, during the 15 years preceding the commission of violent felony, the defendant had been convicted of 2 or more violent felonies under the laws of this state or another state, arising out of separate incidents. Doesn't meet that as well. Then there's another subsection B, a defendant charged with criminal sexual conduct in the first degree, armed robbery or kidnapping with the intent to extort money or other valuable thing thereby. If the court finds that the proof of the defendant's guilt is evident or the presumption great, unless the court finds by clear and convincing evidence that the defendant is not likely to flee or present a danger to any other person. So I most certainly don't find that he poses a flight risk. He is charged with criminal sexual conduct in the first degree. I don't know that proof of his guilt is evident or the presumption great because I haven't seen any evidence. Not to say no evidence exists, I just haven't seen it because the preliminary examination way. So I have to find by clear and convincing evidence that he's not a flight risk, that he does not pose a danger to the community or to that person. information that people have provided to court is that the complaining witnesses moved this defendant and have no idea how to locate it.
To be more specific, Your Honor, because she's scared to stay in her home, she's house hopping.
Again, he doesn't know where to find it. In addition to that, the defendant will be placed on a house arrest tether. His house will be his jail. I'm not sure how you're going to, the court will make allowances for court and medical appointments only. How are you going to survive not being able to go anywhere to court and to doctor's appointments?
It will be hard. I mean, it's gonna be hard,
Would it be easier for you if I just put you in jail? That way you don't have to worry about eating. We'll feed you. You have 3 squares and a cot.
Sir, also may be allowed to finish, but my boss that you talk to, he will provide your counsel. When you talk to him,
Help you out, counsel.
provide the essentials that I might need and help me while I go through this case. I have a lot of support.
Okay. But I figure if you know how to get marijuana, you should be able to know how to get food too. All that being said, the court is going to continue to be the defendant's bond. It will continue to be on house arrest. I'm going to make one more provision for him to go to medical appointments since he indicates that he does in fact have cancer and undergoing chemotherapy. It's important that you get that taken care of or dealt with, sir. So said that you stop taking chemotherapy, probably not a good idea. Cancer is not going to go away by itself.
It was due to my incarceration.
Okay. All right. Now you can restart. Okay. Continue. Thank you.
Thank you, Your Honor.
Again, its court date is April 3rd at 9 o'clock. Good job, people.
Thank
You did. You did your best. You did your job.
It's also hard when you're covering for someone because, you want them to know that you're,
I get it.
if it's your case, it's your case, like someone else's case.
Blame it on me.
No, not at all.
I have these broad shoulders for a reason.
Thank you all so much. I know it was a bit late in the day.
No, you good. Have a great day.
Thank you so much. Your Honor, thank you officer. Thank you all. Have a lovely.
That concludes the docket for today, folks. Hope to see you tomorrow, same bad station, same bad time. Be safe out there.
See you tomorrow, Joe.
All right, take care. Appreciate you.
I had to do another one, so I left the charge off, sorry.
Did you go next up?
I was thinking it might be.
We always invite history.
They called and they said, Arnita, oh, never mind. Then they called back and said, sir, hey, Mary, tell him. The shade, Judge. It's okay. I understand. And then last week, I hope you don't mind, I drew that up for the side. I just said, I continue with the issue of possible. Yes, it's okay. I can't do that. Sorry, for there. Oh, never mind. Hopefully she got noticed to go get a plate because they were looking for her.